Respected dignitaries on and off the dais, our esteemed speaker, Advocate N. Ajit sir, respected members of Bharatiya Abhibhashaka Parishad, and learned advocates and dear friends, good evening. On behalf of Bharatiya Abhibhashaka Parishad, Kerala High Court Unit, I extend a warm and heartfelt welcome to all of you to Study Circle Session 15 on the topic, Legally Restrained, the Law of Injunctions. We are privileged to have with us Advocate N. Ajit sir, an accomplished legal practitioner who has graciously accepted our invitation to share his knowledge and experience. Sir, we are grateful for your presence and eagerly looking forward to learning from you. I also extend my sincere welcome to every advocate, especially our young members whose enthusiasm for continuous learning keeps the spirit of our study circle alive. With these words, I once again welcome you all and wish everyone an enriching and interactive session.
So, our session is on injunctions. Basically, injunction is only an order or a direction issued by a court of law, no doubt. But about the order, that is, which court has to pass the order, that is either the civil court or the criminal court. So we are on the civil court's order giving a direction either to do an act or not to do an act. We know to do an act, we know that it's a mandatory nature. It is mandatory in nature. Not to do an act, that is preventive in nature. So, the first one is positive and the second one is negative. So, negative command, that is what we call preventive orders. Generally, we know what is injunction. That is a negative order directed by the court, aiming at a person, directing him not to do a particular act. So, commonly, injunction, the word injunction denotes an order directing a particular person not to continue with so and so and so. Then what is he being prevented from? That is what we call wrongful acts. Those wrongful acts during our law college time, we might have heard of what is wrongful act. Go back to the first year, second year, law of torts. What is tort? Tortious liability. The veterans like Austin, Danda, etc., etc., etc. Clearly said that is tortious liability arises from the breach of a duty primarily fixed by law. A duty cast on a person, and the remedy is by way of an action in a civil court, either for damages or otherwise. That is the definition. We have studied in the law colleges. That is the first or second year. Taking color from that tortious liability or tort, the injunction basically is an order preventing a person from doing a tortious act. We can have it from the text of order 39, etc., etc. That is preventing from committing waste, acts of trespass, etc., etc. So considering those aspects, that is committing waste,
act of trespass, etc., those are torts against property. That is wrong against or wrongs, civil wrongs against property. So whenever the property in dispute is in danger of being wasted, alienated, trespassed, etc., the civil courts will, by way of an order, direct or command the wrongdoer, asking him not to do that thing or not to continue with your wrongful deeds or acts. So basically, one way, if we are thinking it in one way, injunction is basically aiming at prevention of tortious acts. Basically, it is in certain extensions or certain extents, there are some exceptions are also there, I admit. So, that order, injunction, Code of Civil Procedure provides for injunction under Order 39. That is procedural aspects. Regarding the substantive portion, we can go to the part, I think it is part 7. Part 7 or 6, that is supplemental proceedings. The text section, that is section part, that is 1 to 154, section part, wherein section 94 is there, which speaks for 9 supplemental proceedings. We can see that supplemental proceedings starts with the word in order to prevent the abuse of the procedure or for the prevention of failure of justice or for the prevention of properties. The court can pass supplemental orders or pass orders and supplemental proceedings. There comes a question, what is supplemental proceedings and what is the main proceedings? This one is only a supplemental proceeding. It's only supplements. Passing an order in these processes, that is in 94. Section 94 says certain situations wherein the court can pass an order. Court can pass an attachment order to save the property from being alienated, etc., etc. Then court can pass an order of injunction to restrain committing waste, etc., etc. Appoint a receiver. So those things are only supplemented. Those orders, because why it is supplemented, is given by, explained in a number of judicial pronouncements. Why it is supplemented. It is not main, it is not the main thing. It is only supplemented. Why? The order passed in those supplemental applications do not have any bearing in the final result of the suit. That is only for the purpose of preservation of the property, or preservation of certain rights, or preservation of whatever may be the subject matter of the suit. In 94, you can't see issuance of commission. If you are having the text, or if you are having the text of CPC with you, you can see. In 94, you will be having, or you can't see issuance of commission. Because an order passed under section 94, if commission is there, commission application is there, the report will be having a bearing in the final result of the suit, no doubt. Sometimes the report may say, yes, there exists something. Or the report will be having a fair bearing in the final result of the suit. So that is not a supplemental proceedings. Instead, think of a situation wherein the court passes an order enjoining a person from trespassing upon the property. Initial stage, temporary injunction. Temporarily, he is enjoined from trespassing upon the property. That injunction order, that temporary order, is having no bearing on the final result of the suit. After taking evidence, whether he is entitled or whether he is liable to be restrained permanently then alone a final order will be passed or a decree will be passed. That decree is having no bearing with the initial order. That is only for the purpose of preservation of the property or something, so as to settle the disputed state for the time being only. That is why it has found a place in the supplemental proceedings only. So we should have a bearing in mind saying that what is a supplemental proceeding, what is the main proceedings. Why the passing of an injunction order found its place in supplemental proceedings. That is substantive portion, section 94. Its operative portion is there in section order 39. Order 39, rule 1 to 6 or 7, whatever. Those provisions will give you the procedural aspects of those injunctions, how the temporary injunction has to be passed, how the temporary injunction is to be enforced, how the temporary injunction is to be varied, etc. etc. Then, CPC, if we are dealing with the injunctions having a bearing with the CPC, we are missing something. We are missing a major thing. That is, the injunction is not a procedural relief, basically. What is it? Where else we have seen the word injunction? Where else? That is, somewhere else also we have seen the word injunction. Where we have seen it? Any idea? The word injunction is also mentioned somewhere else. Specific Relief Act. Specific Relief Act, that is the substantive law on injunction. That gives you what an injunction is, what is preventive injunction, what is mandatory injunction. As I told you in the initial time, that is preventive nature means a negative. Don't do that. Mandatory injunction, please do that. A direction to do a thing, that is a mandatory injunction. That is also given in Specific Relief Act. And also, not to do that, not to do a particular act, that is a preventive relief. That is given in a Specific Relief Act, section 38, 39, 40, 41. That 41 takes a step ahead, that is saying that the injunction when can be refused as well. So, those injunctions, those provisions 38 to 41 is the basic principles wherein the court can pass an order of injunction at the end of the day, that is at the end of the suit. Till the end of the suit, the property has to be preserved. Person's reputation should be preserved. Act of waste should be restrained. The person should be restrained from committing acts of waste in the property. So for the time being, the stopgap arrangement is somewhat we can call it as temporary injunctions. Those stopgap arrangement, as you know, CPC gives you the encyclopedia to a certain extent, that is an encyclopedia of what is to be done in such situations. Section 39, Order 39(1), when the injunction is to be granted. 39(2), continuance. 39(3), what should be done by the plaintiff after getting injunction. 39(3)(a), time limit is given. 39(4), Order 39 Rule 4, that says when the injunction order is to be varied, annual, etc., etc., etc. Likewise, every piece of procedure, every piece of activity that has to be done by the court while ordering an injunction, order of injunction, passing an order of injunction, that is given in a true and a detailed manner. So before going to the same, we can identify those provisions that is in the Specific Relief Act. I think it's Specific Relief Act which will give you what is an injunction, what kind of injunctions are to be there. That's 38 and 39. You may just go through that is perpetual injunction, that is we are in chapter 8. Perpetual injunction when granted speaks of perpetual injunctions, not temporary injunction. As I have told you earlier, that is at the end of the day, that is finally the court will pass an order allowing the suit or decreeing the suit, and the decree will say the plaintiff is entitled for a decree as prayed for, restraining the defendants permanently from trespassing upon the property. There comes the question, that is permanent perpetual injunction. When the permanent injunction, that is perpetual injunction. That is 38 and 39 mandatory injunction in the positive. And 40, section 40 of the Special Relief Act. Only four sections are there. That is 38, 39, 40 and 41. 41 is an injunction when refused. So keeping in mind all those provisions, that is section 38 to 41, inclusive of those two different definitions, we can see what is an injunction and how an injunction is given. When the defendant threatens to invade or threatens to trespass upon the property or threatens to commit acts of waste in the property, the plaintiff will come to the court with a petition supported by an affidavit. So, where it is proved by affidavit or otherwise, that is a wording. So, an affidavit is enough, establishing or saying that yes, the defendant is attempting to trespass upon my property. He is threatening to commit acts of waste in my property. So, acting upon that affidavit, so an affidavit is enough. No roving inquiry is necessary at that point of time. The court will find that a prima facie case is there. Prima facie case means at the very first blush there is something. I trust you. That is, the court will say, I trust you, Mr. Plaintiff. I trust you because your affidavit says the defendant is going to do something, some sort of acts of waste in your property. Trusting you on this affidavit filed by you, I am asking the defendant not to do that particular thing for a time being, that is temporarily, either for 15 days, 1 month, or till the disposal of the suit. Till the disposal of the suit, the time is clearly prescribed. So temporarily. And the same will be modified or annulled or whatever may be at the final stage. Whether you are entitled for a decree, if you are entitled for a decree for permanent injunction, you will be given that same at the end of the day. Till that period, your property will be preserved, your property will be kept intact. So that is what we call temporary injunction. So on the affidavit, on the basis of an affidavit, you are given an injunction. The next one is a injunction. If an injunction is given, what will happen? Injunction is ordered. There are certain situations when we are practicing the trial side, we will face a number of issues while we are moving an injunction application. If you are new to a station, you will just ask your friends there, how is that munsif? Is he going to pass an order of injunction, or is he very tough in giving an injunction? So, the munsif may, that is the word used is may, the court may, so that is his discretion. To grant an order of temporary injunction, it is a discretionary order, the court may pass an order of injunction. There comes the first heading. When you are filing an application, you need not get an injunction, temporary injunction. That is his discretion. The discretionary relief is exercised by a court, exercising its discretion only on the equity principles. The person who comes to an equity court or for discretion, he should come with clean hands. He should come in time. Delay defeats equity. A number of equity principles are there, you all are aware of it. So delay defeats equity. plaintiff comes to the court saying that the defendant has trespassed upon my property last month. Now I am free. The last month my daughter's marriage was well, so I couldn't come to the court. Taking it as a plausible explanation, I am coming to the court saying that he is attempting to trespass upon my property. His attempt is during the last month. So please inject him. Definitely the court will ask you a question, where were you at the time? So delay defeats equity principles. The court need not give you an injunction at the first blush itself. Court can give you only a notice. Court can issue a notice only. Issue the other side a notice. Urgent notice or a usual notice. Asking the respondents or the defendant to come and submit something on the allegations given by the plaintiff. So the word used is the court may act upon your affidavit or otherwise. Otherwise means on the documents or the other evidence, etc., etc. So may means discretion. The court need not give you the order. And passing an order immediately. Order 39 Rule 3 is there. I'm skipping order 9 Order 39 Rule 2 first, and 3 is there. Immediately you will have to do certain formalities. What all are the formalities? Anyone has an idea? What you have to do? On getting an injunction order, what you have to do? Pardon? Communicate to the other side by way of with a copy of the plaint and all those things. If you are not doing the same, you may lose the injunction order. So 39(3) is there. And on receipt of those notice, the respondent will appear in the court, and what he will do, he will give his explanation or he will file a counter to the injunction application, and he will ask for vacating the injunction order. And the court may vacate the injunction order, or the court may make it absolute. There comes the next question, Order 39 Rule 4, very sparingly used or very rarely used provision by the lawyers. On getting an order of injunction, immediately the lawyer will ask his friend in the higher forum, that is either in the High Court or in the District Court or whatever may be. Please go to the higher forum and get an order from the higher court saying that that order is, the injunction of order is very bad, that is to be vacated. Instead of doing that, there is a provision in the CPC itself, the code itself. The code says, first you have to move an application under Order 39 Rule 4 to vary the injunction, to annul the injunction, or to vacate the order of injunction. You have to establish your case, that is the defendant, asking the defendant to establish his case first. And even after the court is not passing an order vacating the same, you can be said or you are aggrieved. Then alone you can go to the appellate forum under Order 43 Rule 1, an appealable order, that is the substantive provision is 104. 104 CPC says appealable orders. And Order 43 is there, Order 43 Rule 1, Order 43 Rule 1, K, I think it's K, Order 39 Rule 1, Order 39 Rule 2, Order 39 Rule 4, etc., etc. Whenever an order is passed and if you are feeling aggrieved, you can go to the appellate forum. And if you are moving the appellate forum with a CMA, Civil Miscellaneous Appeal, against an order of injunction, that order of injunction, either it will be made absolute or it will be vacated by the appellate forum. And against that order, whether a second appeal is maintainable or not, that is the next question. What we have to do? In CMA, we lost the CMA, or the other one succeeded in the CMA. What is our remedy? An order is passed in CMA. That CMA is dismissed. That is, CMA is against an order in the Order 39 Rule 1 application, passing an order against us, a temporary injunction against us. We filed a CMA, and that CMA, we lost it. What is our remedy? Note 4, subsection 4, clearly says no second appeal. You can't go against an appeal. You can't prefer an appeal against an order in an appeal. So the only remedy is either a CRP or 227, generally, Sarvavya. That is, revision CRP is maintainable. CRP revision will be maintainable only when what is the provision for civil revision practice, or what is the ground for a revision. If that order was passed in my favor, that would have put an end to the litigation. That is one thing. Either wrong exercise of jurisdiction, non-exercise of jurisdiction, mal-exercise of jurisdiction, want of jurisdiction, etc., etc., etc. So there is no second appeal or second time you can't move an appellate forum against an order passed in an appeal from an appellate order. That is Order 43, Rule 1 order. So these are the basic principles you have to keep in your mind while dealing with an application for temporary injunction. As I told you earlier, this is basically on an equitable principle, no doubt. So there is no hard and fast rule given by the statute. The legal principles are developed by the courts, either by the equity courts or by our Supreme Court or High Court, whatever, the courts higher forums. How an application under Order 39 is to be dealt with, how the word may is to be beneficially or legally employed or used, that way everything has been taken care of by the higher forums, that is the High Courts as well as the Supreme Court. The American Cinnamon case was there. I think that is in 1985 appeal case, I think so. American Cinnamon case is a basic principle given in the American. You may be wondering why the American case is acceptable for an Indian law. They adopted a principle that is a best triable case. While dealing with an application for an injunction, the court should be satisfied that there is a triable case. Initially, the court should be satisfied, that is the American principle. There should be a triable case. Then alone the interim injunction application will be entertained. Taking the color from that Cinnamon case, Indian courts followed the same till 2005. Even in 1995 there was a case, that is Colgate-Palmolive is there. The said Hidalgo's case is there. Everything will say, taking color from that Cinnamon case, that is the first triable case or the triable issue, it has been transformed to three, that is trio principle test. What all are the trio principle tests? What should be there in mind? What should be the guiding principle of the civil code while dealing with an application under Order 39 Rule 1 nowadays? Yet three tests are: first one, the existence of a prima facie case. American system said a triable issue. We have considered the same and we have taken color from the same, and now come to the conclusion that there should be a prima facie case. Prima facie, the plaintiff has to establish that there is a case. Next one is what is it? Balance of convenience. Prima facie case, balance of convenience. What is the balance of convenience? Again there comes the equity principle, tilting. The court is tilting. Whether granting of an interim order is kept in one platform, and the non-granting of the injunction order, putting it on the other platform, which one will weigh? Whether granting will be beneficial for the preservation of the property, or refusal will have no implication or will have no effect on the issue. Then the court will, if no effect is there, the court will refuse to grant a temporary injunction. So balance of convenience is there. Then what will the third one? What is the third one? What is the third one? irreparable injury, the granting of injunction will prevent the happening of some injury or the causing of injury to one side, or the refusal of injunction, temporary injunction is going to cause nothing, then it is better not to give an injunction. So all these tests, these trio is now the principle in the Colgate family onwards. So those principles has to be kept in mind. With the equity principles, that is, as I have told you earlier, that is specific relief act gives the power of the court. Specific relief is basically on equity principles. In all those situations, 38, 39, 40, 41, the court may, the word used is may, so the discretion is exercised, should be exercised legally and judiciously. To exercise the same, you should be, the court should have in its mind the equity principles. So the delay, etc., those things will weigh the balancing. Then, leaving all those things, we can discuss one more thing. In 1951, Travancore Cochin and 53 Travancore Cochin, two important decisions are there which the lawyers, we the lawyers, should keep in our mind. Notice is as good as injunction. Have you ever heard of it? Notice is as good as injunction. Have you ever heard of it? Because I am telling you this, because these two decisions, though that may sound old, that is Travancore Cochin decisions, that is useful in our life, in a lawyer's life. Because I will give you an example, that is the plaintiff is having a number of civil suits. He is dealing with a number of civil suits, and plaintiff, the defendant against whom he is filing suits, he has engaged a lawyer, and he was there in the court. When the defendant's lawyer was there in the court on a fine afternoon session, a lawyer was moving a suit which is familiar with the facts to that lawyer, because he knows there are a number of suits in between the plaintiff and the defendant. But the munsif has not given an injunction order, or temporary injunction was not given. But the suit was moved, and the defendant's lawyer, that is the proposed defendant's lawyer, was sitting there. Then the third case, or sixth case, the lawyer was there. He knew this is concerning my client, to whom or for whom I am appearing in all the other cases, wherein the court has not given an injunction order. Immediately he telephones his client and says, against you a new suit is moved, wherein no injunction is passed, or no injunction order is there. You can do whatever you want. There is no injunction order against you. You can do whatever you want till the court receives back the summons issued to you, and till you are filing the application, the reply and all those things, nothing is going to happen. You can pull down his structures, you can trespass upon his property, you can cut down his valuable trees, whatever you can do, because there is no injunction order. If that lawyer is instructing, or if that lawyer is advising his client like that, 51 TC and 53 TC says, notice is as good as injunction. That is, again, later decision in 85, I think it is 85. 85 says, notice to lawyer is notice to party. Combining these three decisions, combining all these three decisions, 51 TC, 53 TC and that 85, will give a clear picture saying that if notice is having, if the lawyer is having the notice of the institution of a suit, he is restrained, or he should be, it should be considered as notice is as good as an injunction order. Because the matter is lease, the pending lease. A pending lease for consideration before a court of law. So those two decisions, and the third one, notice to lawyer is notice to party, will give you or give us a better say even if no injunction is granted. Because I had an occasion, because my personal experience I can tell you, I had an occasion where I filed a suit, the municipal refused to give me an injunction. The third day or the fourth day, the defendant did the very same thing, because we were having a number of suits in between, and the lawyer was there, he was attending other cases, but he knew that the new suit is pertaining to the same parties. Though there was no injunction, or since there was no injunction, the other defendant trespassed upon my property and that has done something. I was entitled to, or I could move an application for violation of that injunction order. Only on the strength, saying though there is no injunction order, I had filed an application, and in that application I had submitted that notice is as good as injunction, because the other side was having notice. After receiving that notice, what happened to that application, that is another thing. That application was posted along with the suit. That violation application was posted along with the suit. That is the plight of the suit. But my application was entertained only on the basis of those two decisions. So please keep in mind that situation. Then comes Order 39 Rule 2(a), that is violation of injunction. Violation of injunction is punishable. Up to 50,000 rupees can be fine can be levied, and he can be detained. Not all. Conjecture is there, and he can be detained in the prison. Then 39(3) compliance. 39(3)(a). 39(3)(a) says time limit. That is gives the time limit within the application should be disposed of by the court. From the date of filing of the application, 30 days, within 30 days of filing the application, that application should be disposed of. Have you ever heard of such a situation? Within 30 days, the 39(1) application is disposed of? No. That is kept pending for years and years. So 39(3)(a) stipulates the limitation, that is 30 days time. 39(4), Order 39 Rule 4 says, that is, you can file an application to modify the injunction, varying the injunction, and so on. These are the guiding principles for injunctions initially. That is only peripheral idea. You can go to 41 specifically fact. Go back to 41 specifically fact, where injunction can be refused. The court says that is in certain situations the court will refuse injunction. That is at the end of the day, the injunction will be passed. That is permanent prohibited injunction will be given at the end of the day. That is by way of a decree. When an injunction can be refused, when the court can refuse an injunction. 41 A, B, C, D, etc. given to J or K, up to K, I think. Can anyone suggest a situation where the court can refuse granting an injunction? Anyone remembers those provisions at section 41? Sorry, I couldn't. When there is either alternative efficacious remedy, it is, I think it is 41H. 41H, I think it is 41H that says when there is another efficacious remedy, injunction will be refused. Usually during March, February last March season, the Municipal Court when we were practicing the trial side, the Municipal Court will be flooded with the suits against RR proceedings. Civil courts, the Municipal Courts will be flooded with RR proceedings, because the claim of the plaintiff will be that the defendants are trying to trespass upon my property. You should keep in mind that first one is the district collector, the second one is the village officer, the third one is the Tahsildar, the third one is the village officer, second one is Tahsildar, RR, deputy collector, etc. They are trying to trespass upon my property. We will make out a case like that and take away my old valuables. On the premises, false premise of a RR demand notice. Normally, no injunction will be granted. That urgent notice will be given to the other side, and the court will definitely dismiss the suit on this ground, because against attachment, Revenue Recovery Act section 50, I think it sets section 58, there is a provision for objections to attachment. You can file an application before attachment before the Tahsildar or the village officer saying that my properties are not attachable for the debt. Without hosting the other remedy, if there is other efficacious remedy, without hosting that remedy, you cannot straight away come to the court asking for an injunction relief. So on that score, the injunction will be refused. Another ground, is there any other ground? That is a new concept, that is 20, I think section 20A, specifically if I have amendment has brought about some issues, that is infrastructural projects, that is building a road, building a shipyard, or building some national highways, etc. You can go for an injunction suit against that infrastructural development projects, wherein the nation's growth will be stalled. That is the reason. The nation's growth will be stalled. That is the reason we are not going. The court will refuse to grant an injunction order. The other one, next one will be a situation where the court has to give continuous supervision for the enforcement of the injunction. In such a situation, the court will refuse the injunction order. So, those things are to be kept in mind while deciding an application of injunction at the later stage. What matters in the initial stage is only the preservation of the property, preservation of the subject matter of the property. There comes the next question. We might have come across such a situation, that is interim mandatory injunction. Have you ever heard of that situation, interim mandatory injunction? What is interim mandatory injunction? Status quo ante. We can call it as status quo ante. What is the status quo? What is the status quo? How the municipal can understand what is the status quo as on the date of the suit? How we are managing it? By way of a commission, no doubt. But what was the status quo ante? That is at the time of the institution of the suit. Before the institution of the suit, there was a wall. That wall has been demolished by the defendant. Partially demolished. Then he comes to the court saying that the defendant is to be restrained from further demolishing the wall. So the further demolition can be stalled by way of a temporary injunction, and the former demolition can be made good by way of an interim mandatory relief. That interim mandatory relief will be risky for the court, and the courts are very slow in granting an interim mandatory relief. Only in the rarest case. I am not telling about the 302 matters. Even in this type of interim mandatory prayers, only in rare cases and the rarest cases, the courts will give interim mandatory, that is status quo ante. There also, while I was practicing the trial side, I had an occasion to come across such a situation wherein a bus was flying in between two particular destinations, that is from Trichur to Kodungallu. In between my area was that is in Irinjalagoda was there. A private financier financed the bus, wherein the bus owner defaulted in paying the money. The bus was first one attached, injuncted the revenue, that is the transport authorities from transferring the property to some other person, injuncted the owner from plying the vehicle. Then we filed an application for interim mandatory prayer saying that we should be permitted to play the vehicle, because the non-granting of that interim mandatory prayer will affect 6 or 7 family, that is the employees in the bus. In such a situation, we have made some more advances saying that the defaulted amount or the amount we are liable to pay to the financer, we are ready to pay the amount in the court. Then the court gave us an order, that is interim mandatory prayer, allowing us to play the vehicle and take back the vehicle only on the condition that the amount should be deposited in a nationalized bank and the court should be given an account for the same. On that condition we have to adhere to. In this case, interim mandatory injunction. So these are the broader or a peripheral principles governing the granting of injunction. Regarding the injunction, as I have told you earlier, there are a number of decisions. That is, a number of decision means that is judge-made laws. Judge-made laws rule the field. They rule the field. That is, granting of injunction and etc. is governed or managed by judge-made laws, not the statutes. From the first question, that is the triode test, till the end, that is how far the injunction order is to be managed, modified, vacated, varied, etc. Everything is being taken care of by the judge-made laws. We can follow only the substantive law, that is specifically effect wherein the injunction is refused. That is 41. That can be managed. Managed only in the final stage, or that will come into operation only in the final stage. That is whether the injunction is to be refused or not. But till that time, how the field is to be managed, that is properly managed by the judge-made laws only, not the substantive law or the statute. So we should have a clear understanding of what the higher forums have told or have described about what should be the modus operandi in dealing with dealing with such applications. That is to be thorough with the lawyer. If the lawyer is not thorough with the judgment laws, we may miss the bus. So we can't take shelter under the substantive law. We have to follow the judgment laws. Because mainly this is led by equity principles. So I will tell you, if you are having piece of papers with you, I will give you 3 or 4 some useful decisions in your advocacy during your practice. If you are interested, you can take it down, because that I feel that will be useful. One of the same is that Dalpat Kumar, that is a basic decision, that is a triple test decision, that is 1992 1 SEC. Dalpat Kumar versus Prahlad Singh, that is 1992 1 SEC 719. That says how an injunction appeal, because why I am giving stress on the same, because while drafting an application, you can simply say that for the reason stated in the accompanying affidavit, it is simply prayer that the Honorable Court may be pleased to injunct, pass an order of injunction against so and so. Enough. But in the affidavit, if you are making all these things, that is prima facie case is made out so and so, and the balance of convenience is in my favor, etc. If your affidavit says that, those in adherence with the principles, your affidavit will be a perfect affidavit. So we can bang on that affidavit because we are following the principles that is given in 92. So first one is 1992 1 SEC 719. Next one is Mahadev Savalram Shilke. That is Mahadev case. That is in 1995 3 SEC. 1995 3 SEC 33, page 33. That shows what is irreparable injury. So you are not beseeching or you are not begging in a court of law. You are saying that if the injunction is not granted or if the injunction is not passed in my favor at this point of time, the injury that will cause to me, that is irreparable, your affidavit should be drafted in such a fashion that is in tune with that 1995. 1995 3 SEC page 33. A useful decision. Then what is a strong case? That is, what is a prima facie case, what is a strong case, what is a triable case, etc., etc. That also should find a place. That should find a place in your affidavit. That is given in 2005 SEC. 2005 SEC 573. Why I am giving stress on these three decisions is, if you are able to bring out your affidavit in tune with these three decisions, if the municip is refusing your application, no doubt the higher forum will entertain your application. Because even though the trial court, even though you have made out all those things, all these stipulations in your affidavit, all these things in your affidavit, non-consideration of these things clearly established that non-application of mine by the court. That is non-exercise of jurisdiction. Non-exercise of jurisdiction by the court while dealing with an application toward the government. This is not a guarantee from my side. That is, the appellate court will entertain it, and the same will be passed in your favor. I can't say, because something, many other things will happen in the higher forums. I can only say, this is, if these principles are enunciated in the affidavit, and even though you have done all these things, the municip is refusing your application, and if you are approaching the higher forum has to say that non-consideration of these matters is a perverse finding of the court can interfere. That is, legally it can interfere. Actually, in practice, what will happen, that is up to the plight of the party. So generally, this is happening.
Sir, last citation.
First citation is in 1990. 2005 SEC 573. Volume 5, 2005. So, with these things, I am summing up now. We can have a discussion. If you are interested in putting questions, I will try my best to give you an answer. Any suggestion or questions?
So normally, when it comes to the preliminary injunction by the lower courts, there is a trend that normally it will run till the conclusion of the suit. Is there anything that we can do about it? Because most of the, even if we are filing an objection or we are filing a petition to vacate the initial interim and interim intention.
Order 39, Rule 3A, that is in print, that is the statute, gives an outer bracket, that is within the period within which the same has to be disposed of. That is 30 days. When you file an application, the other side should be given an opportunity to interject or object. That objection should be heard and disposed of within a period of 30 days. Whether that 30 days will endure till the end of the day, that is up to the lawyering community as well as the interest of the party. Because why I am stressing this, because nowadays we are hearing something that is delay. Actually, what is the reason for the delay? I am not saying that there is a number of cases are piling up. No. A money suit is decreed. I will tell you one thing. a money suit is decreed, that is directing the defendant to pay a certain sum of 3 lakh to the plaintiff within a period of 1 month from the date of receipt of this order. Immediately on receipt of that order, the defendant will come to you. What he will say? Sir, എങ്ങനെയെങ്കിലും ഇതൊന്ന് പിടിച്ചു നിർത്തണം, മകളുടെ കല്യാണമാണ്, സാർ എങ്ങനെയെങ്കിലും ഒരു സ്റ്റേ വാങ്ങിച്ചു തരണം. രണ്ടിൽ ഒരാളുടെ ആവശ്യമാണ് സ്റ്റേ, രണ്ടിൽ ഒരാളുടെ ആവശ്യമാണ് ഡിലേ. അല്ലേ? ആലോചിച്ചു. ഞാനൊരു 10 മാസം കൊണ്ട് കൊടുത്തോളാം, അല്ലെങ്കിൽ 12 ഇൻസ്റ്റാൾമെന്റ് കൊണ്ട് ഞാൻ കൊടുത്തോളാം, സാർ ഒന്ന് 12 മാസം ഒന്ന് ചവിട്ടി പിടിച്ചു തരണം. We will file one application, we will file another application, we will file the counter, we will file the goal, and we will go on with the application. If it is in execution stage, there are 106 provisions. 21, order 21, rule 106. So, delay is a need of one side. If you are getting an order of eviction, if you are for the plaintiff and the plaintiff is given an order of eviction, that is, the defendant is directed to vacate the premises immediately on receipt of the same, and the defendant comes to you, what he will say? Sir, please get a stay. RCP, RCR, etc., etc. What the RCP tenant will come to you and say? Sir, please get a stay. I will vacate the property only after 6 months when my daughter's marriage is about to happen in November or December. So please give me a stay. So it is a need of one and the same. In matrimonial appeal cases, husband will prolong the matter so that the wife should not remarry. The wife will prolong the matter because the husband should not go for a remarriage. We will file one application after another. Then in a motor accident based tribunal cases, filing, number of cases are filing up, no doubt. Why the delay? The petitioner's counsel or the appellant's counsel will not go to the court for arguing the matter because in the bank they will give you only 4% interest. In the motor accident cases, they will be giving you 8% interest or 9% interest. Who is benefited? At the end of the day, the injured is benefited after 10 years, 18 years, for 15 years. So he will be benefited. So delay is a need of one side. So why the same is not disposed of within 30 days? That is what we call advocacy. That is art of advocacy. You are knowing the provisions. If you are knowing the provisions in a better status, you can prolong the matter according to the whims and fancies of your client. So 30 days is a statutory prescription. That 30 days will prolong for 1 year, 2 year, 3 year. That is, if the party is going in a CMA and the CMA against the CMA is CRP is filed or an OPC is filed, and against the OPC order they are going to Supreme Court. If he is fortunate enough, he will get an order in the SLP and stay in the SLP. There will be end of the matter. That is the reason why 20A is incorporated in the Specific Relief Act. That is, no injunction should be granted against an infrastructure project. Nation's growth will be stalled. The presumption is there. Just like Abkari Act, Section 64 Abkari Act. Section 64 Abkari Act, there is a presumption that when an offence is committed, the presumption is that he has done the offence. It is foreign to revert the presumption. Just like in TPS Act for Abkari Act, etc. This presumption, that is an injunction, if an injunction is granted, the nation's growth will be stalled. That is a presumption. So the statute says no injunction should be granted. Likewise, that is the demerits of the system. That is Order 39 Rule 1 system. That is the entire procedure system. The demerits are, one thing is that is delay. That is the art of advocacy. You can manage things. The second one, we will never comply with Order 39 Rule 3. Fourth one, we can't say it openly, that is, we are doing forum shopping. If the principal municipality is not giving the injunction, we will file a money suit there. We will get the second number in the additional municipality. The additional municipality is giving an injunction, so we will go to that court. So that promotes or gives a lever for forum shopping. Then economic stalling, etc., etc. These are the demerits in the Order 39. But one thing we have to keep in our mind, these provisions are the lifeblood of civil litigation. Because one may find it difficult or bad in the situation, but the other one is benefited by the situation. So this is the lifeblood of giving an injection for a long time. That may be beneficial for the other side as well. In the guise of an interim injunction, we can manage things. And even an injunction, if an injunction is given and a violation is actually happening there, that is pulling down, an injunction is there, injunction is filed against demolition of a wall or construction of a trespassing upon the property and putting up of a wall, trespassing upon my property. No injunction was granted, no temporary injunction was granted. Then I am pulling down a portion of the wall. Then the suit has to be managed or suit has to be amended to incorporate a mandatory provision. A mandatory injunction can be decided only on the basis of evidence. It cannot be decided only on the basis of affidavits or something like that. So that evidence taking is a long process and the suit will go on for 1 year, 2 years, 3 years. So initially it was only an injunction, temporary or prohibitory injunction. When it is transformed into a mandatory injunction, the suit will be having a longer life. That will be beneficial for the wrongdoer, not the injured party or the aggrieved party. That's all. Any other question or any other suggestions?
Can an initial mandatory injunction can be granted to restore status quo and negate the data suit?
Status quo?
Not as of the data suit, but status quo and negate to the data suit.
Status quo anterior can be given, but only in a rarest cases. Only on the basis of strong evidence saying that there was something in existence at an earlier point, an anterior point of time. If you are able to establish that thing, the court may. There also the situation is may. So you can't ask it for as of right. Court may. If the court is not giving you can't because it's a discretion. Just like issuance of cost, that is cost is a discretion of the court. You can't go against an appeal against the cost. It's like the same. If mandatory injunction is not given, the court ought to have given me an injunction. You can't say so. What weighed the mind of the court, that is up to the court. Any other thing? No.
There's a difference between balance of convenience and irreparable injury. There's complementary.
In effect, it is not complementary. Balance of convenience, that is giving an injunction at one point on the basis of one set of facts and refusing the same on the another set of facts is one thing. An irreparable injury, that is injury that will be caused to the plaintiff if the injunction is granted or if the injunction is refused, and the injury caused to the defendant is minimal, that is different. What is an injury? What is legal injury? It can be legal injury, economic injury, and status injuries as it is. But balance of convenience is only for the sake of preservation of the property. If something is ordered, that will not have a bearing in the final result of the suit. Saying that the defendant is trying to trespass upon my the defendant is trying to dispose of the property so as to defeat my interests. The defendant may be injuncted. The balance of convenience says if injunction is granted, the defendant will be restrained from transferring the property to another person, and the munsif refuses to give you the injunction. The balance of convenience was in your favor that it ought to have been given in my favor. The munsif is of opinion that the same will be a sub judice. Pending litigation, some transfer is there, 52 will be attracted. You go there, you can establish your right under 52 TP Act, lease pendants. So I am not going to give you the same. So the balance of convenience alone was taken into consideration. Then the question of irreparable injury. If the injunction is given, like the earlier earlier situation I gave you, that is the bus is plying in between. If the bus is attached, the bus owner is injuncted from plying the vehicle in between for 1 month or 30 days or 40 days, whatever may be, the injury that will affect the owner of the bus is on the one side, and the amount of installment amount that has to be paid by the owner to the financier is on the other side. If it is only 10,000 rupees, and the grant of injunction will cause hardship to 6 or 5 families, economic injury will be higher. That will be in a higher pedestal than that of granting the injunction. So that will be considered by the courts.
Comparative hardship.
Comparative hardship, that is more or less to the comparative hardship and not on the price of convenience. There is a difference. Though it is a subtle difference, it has got its own bearing on the considerations.
But the communication of part of the data is something that really led to the concern. Is there any clarity?
SRO,
Some cases it is communicated, some cases not communicated.
I think it is in 2004 there is a decision saying that it is to be communicated to the SRO. That is, the injunction is passed or an injunction is given in favor of the plaintiff, injuncting the defendant from transferring the property. Alienation. That alienation, if it is not communicated to the SRO, the sub-registrar will execute another deed. So, 2004, there is a decision by the Kerala High Court saying that if it is insisted by the plaintiff, the court has to intimate the registrar. If it is insisted by the plaintiff, it is not mandatory. So, it is for the interest of your client, that is, it is for the best of your interest. You have to insist the court while passing an interim injunction order, please communicate the same order to the SRO. Then alone the same will be reflected in the SRO's books. A decision gives you power, but the decision again says that you have to insist the court. That is, the duty is on the plaintiff.
This means it should be in the petition.
Need not be in the petition.
What is it?
Even in oral submission can be enough.
Even without oral submissions, courts usually intimate this.
That is in the interest. First one is in the interest of justice. Second one is on the facts and circumstances of that case. If the affidavit clearly says there is every attempt to trespass or every attempt to alienate the property, there is every chance that the injunction, even though the injunction is given, if it is not intimated to the SRO, the property will be transferred to another person, and that will give way for multiplicity of proceedings. The municip can intimate the same to prevent the multiplicity of proceedings for abuse of the process of the law. Because the other side has to come to the court with a declaration suit. Next one is a declaration suit saying that the second transfer is void or bad, or it is hit by Section 52 Transfer of Property Act. Second suit, that will give way to number of suits. So, to prevent the multiplicity of litigation, the court can pass on the communication to the SRO. But that I think it is 2004 or 2005, there is a decision by the Kerala High Court saying that the same is to be intimated to the SRO on the insistence of the party. Party means the party's counsel. So, it is your duty to protect the interests of your party. Or it is not the duty of the court. Any other question? No. I think all you are enlightened. Thank you. Thank you so much for the patient wait.
Respected Speaker, Advocate N. Aditya, distinguished members of the Bharatiya Abhivashaka Parishad, learned advocates, Ladies and gentlemen, good evening all. As we come to the close of today's study circle session, it is my pleasure duty to propose the vote of thanks. On behalf of the Abhibhashaka Parishad, Kerala High Court Union, I express our sincere gratitude to Advocate N. Ajit Sir for delivering such an insightful and engaging session on the law of injunction. Your practical guidance, clarity of thought, and willingness to share your experience have undoubtedly enriched all of us. Thank you, sir. Now, I thank all of you who are present here with your presence and as well as your support. We look forward for the meeting you all next time. Thank you all.